Hi, I'm Sarah with Phillips Law, a criminal defense firm based out of New Orleans, Louisiana. If you or someone you care about has been charged with a crime, you might have heard the phrase motion hearing. And if you're like most people, you're probably wondering, what is a motion hearing and why does it matter? A motion hearing is a court date where the lawyers go in front of the judge and ask for decisions to be made about how the case should move forward. So for instance, it's not your trial. No one is deciding if you're guilty or innocent that day. Instead, what we're doing is we're more or less talking about the rules, right? So for instance, what evidence should be allowed? Was everything done the right way? Are the charges even legally correct? Think of it like a referee making calls before the game starts. The lawyers are raising their hands and kind of saying, Judge, we have a problem. We need you to rule on this before we can play the game. So when do motion hearings happen? They usually happen right after your arraignment and after we've received all of the evidence from the district attorney, what we call discovery. Now, remember, discovery is a huge part of building your defense, and if you're not sure about what that is, we have a whole other video that breaks that down. So check that out if you want a deeper look at what discovery means and why it matters. Now, once we've had a chance to go through all of the evidence, we might file motions, which are formal requests asking the judge to take action before trial. So what kind of motions do we normally file? There are several, and each one serves a different purpose. Some of the most common ones include motion to suppress, which is where we ask the judge to throw out illegally obtained evidence. Motion to quash, which is where we challenge whether the charges were legally filed. Motion for competency, asking whether the defendant is mentally able to stand trial. Motion for a speedy trial, if the case has been dragging on for too long. Motion for discovery compliance, so if the DA isn't turning over discovery that we believe they're supposed to. So we'll be posting separate videos breaking down each of these, so if you want to learn more, subscribe or check out our channel. So the next question people ask is, how does a motion hearing actually work? The side who filed the motion, whether that's us or the DA, goes first. We can call witnesses, ask them questions, and present evidence or arguments to the judge. Then the other side gets a chance to cross-examine those witnesses and respond with their own side of the story. And they get to call their own witnesses as well. At the end, both sides give final arguments and the judge decides. Now, that decision can have a big impact on your case, sometimes even leading to a dismissal if the judge throws out evidence or finds no probable cause, that kind of thing. Some people want to know, do I have to testify at a motion hearing? In most cases, no, you won't. As your criminal defense attorney, we try to limit your exposure, and here's why. Even if you're confident going on the stand, it's hard. You're under pressure, the questions can feel aggressive, and it's easy to get flustered. More importantly, if you testify during a motion hearing and later testify at trial, anything you say that's even slightly inconsistent can be used against you. That's called impeachment, and it can really hurt your credibility with the jury. So unless it's absolutely necessary, we won't put you on the stand. That's just part of our job, is to protect your rights and your case. So why do motion hearings matter so much? Because they can change everything. Let's say we file a motion to suppress and the judge agrees that the police didn't have the right to search your car. If the evidence they find gets thrown out, the DA might not have enough left to go to trial. And in that situation, they may have no choice but to dismiss the case because they don't have the evidence. So even though it's not your trial day, motion court and motion hearings are still a very big deal. Motion hearings are really where we push back. It's where we challenge about what the state is doing and where we can really start shifting the case kind of in your favor, showing the district attorney and the judge, kind of the flaws in their case, if you will. So if you are a current client and you have any questions about your upcoming court date, do not hesitate to reach out. You know that we're always here for you. We want to make sure that you feel informed and supported every step of the way. And if you don't have an attorney and you're facing charges in Southeast Louisiana and you're thinking, man, I need a lawyer who actually explains stuff like this, give us a call. Our number is 504-395-8867. We'll be happy to talk with you for free and let you know how we can help.